Hey, everybody. Welcome. Happy True Crime Wednesday. You can see our true crime quilt is taking shape. You can see some new squares up here, and you can see that kind of match our theme for Wednesday nights. And it's all coming together. Hopefully, we'll get the last the video for the last couple squares up in the next day or so. Been having a little computer issue, but I think we have it worked out now. And so just want to say thanks to everybody for being here. I'm just going to take a minute while everybody joins in because we have a lot to talk about today. Thank goodness it's True Crime Wednesday. And so there's a lot, as always, to talk about in the true crime world. So we have a lot to talk about Vallow Daybell. We're going to touch on that, and we're going to get into it deeper on Friday when we talk about all things Vallow Daybell. But there are a couple of other things that have happened that I wanted to highlight before we get into in deep on Vallow Daybell. So first of all, Letitia Stout, her trial is coming up in Colorado. It's actually expected to start about the same time as the Vallow case here. Here meaning I'm in Boise. So they are going to start jury selection somewhere around the 20th of March, and the substantive case should start the same week as the Vallow Daybell case starts. So that will be very interesting for those of you who aren't familiar with that case. Letitia Stout was a stepmother whose young stepson, Gannon Stout, disappeared. They later found his body in a suitcase in Florida and had plenty of proof that Letitia Stout had, in fact, driven the body down to Florida. That case has been pending for 3 years while she has fought on and off mental health claims of not guilty by reason of insanity. And so it will be interesting to see how that one goes. Of course, Vallow Daybell is starting that same week in April. There's a lot to talk about Vallow Daybell, including about how the trial is going to be conducted in Ada County. Judge Boyce just put out orders on what that trial is going to look like, and it's interesting. But I first want to talk about a couple of other cases. We do have some movement, a little bit of movement finally in the we have a few new developments in the Kohberger case, which is the University of Idaho murders, and one of the things to talk about is that Brian Kohberger, they recently released the return on the warrant, the what is returned from the sheriff to the court when they process a warrant, and it includes an inventory of everything that was taken in the warrant. This was the warrant that was served when he was arrested and was served in his parents' house in Pennsylvania. And there were some sort of interesting things and a few little interesting observations that they made, such as that he was up in the middle of the night bagging up his personal garbage in Ziploc bags, which is sort of interesting. There were a few things that were seized, several knives, some surgical gloves. He was wearing surgical gloves at the time that he was bagging up all of his garbage. And so that was sort of interesting. It also was interesting that there was a transcript released recently of an in-chambers hearing that happened having to do with the possible conflict of interest with his lawyer, Ann Taylor. And as I said, no conflict. One of the things that she pointed out was the fact that she had never actually met with Kara Kernodle, or I think her name is Knighton now, or McKnighton, because what happens in many jurisdictions is that the court docket will show if the public defender is appointed, it will have an attorney's name, and it could be the lead attorney in that PD practice, and it may not necessarily be actually the lawyer that's assigned. So sometimes as cases go on, once that case is actually assigned to a lawyer in that public defender organization, then the court would update their file and show that there was the actual attorney that was appointed. I'm not surprised at that. It happens frequently. It's the court's docket on the assigned lawyer is not necessarily all that reliable, because those things change as appointments come and go. And so, I mean, I'm sure if you went through the court dockets from when I was practicing, I could have been appointed on cases that I wasn't really on. And conversely, I could have been the lead attorney on cases that showed somebody else as the lawyer. Sometimes it's as simple as the lawyer who appears and picks up the initial indictment, makes the initial appearance, can be listed as the attorney when somebody else is actually appointed. So it wasn't all that surprising that, in fact, the court found that there wasn't a conflict. Ann Taylor just recently requested a second attorney, and one has been appointed. Somebody else who is also death penalty qualified. And so this case is still moving on ahead, and his preliminary hearing is scheduled for June. And I'm planning and hoping to be there. A lot depends on the Daybell case, but hopefully by June we will have brought the Daybell case to a conclusion. So there were a couple of other really interesting developments. There's been an arrest in the Dylan Rounds case. Dylan Rounds was a 19-year-old young man from Idaho who was in Utah dry farming, and he apparently got sideways with a guy who was squatting on land nearby, who was not a very nice person. His name is Brenner, and he was in jail on a firearms charge, on a federal firearms charge, because he was a felon in possession of weapons when he was charged in Dylan Rounds' case. The fascinating thing is that while they were searching for Dylan, they didn't find Dylan, but they were able to find his telephone, and it had been thrown into a pond, and they were able to recover the phone out of the pond, were able to extract information from that phone, and were able to pinpoint his location as having been with Brenner at the time, the last time he was known to be alive. The other interesting thing is that on the phone, they found a video, and the video shows Brenner cleaning a gun, and he has blood all over his shirt. When the authorities recovered that shirt and tested it, they found both his blood and Dylan Rounds' blood on the shirt. Dylan's body has not been recovered yet. There's likely still snow there. And I know that they are trying hard to recover his body, but they have not. Brenner has also been charged with the abuse of a corpse. So we don't really know what that means. We don't know whether it's simply that he's hidden a body, or whether or not there's some other more unsavory things going on. So we'll have to wait to find that out. But it's good news for Dylan's family because they have said all along that somebody out there knew about Dylan's whereabouts. So I want to dive into Vallow and Daybell for just a few minutes. I'm going to chat for a few minutes, and then we'll be asking y'all to give us your questions. I don't generally like just reading things out loud to you, but I think that there are some really interesting things to talk about in the defense's motion in limine that I do want to read verbatim to you. So and there also are some interesting things in their motion to dismiss the death penalty. So the first thing they filed, this is Jim Archibald and John Thomas on behalf of Lori Vallow. Now, you may remember that the judge has severed these cases, and Chad Daybell's case has not been reset yet. But Lori Vallow's case is going full steam ahead on April 3rd. So her attorneys filed, first of all, a motion in limine to exclude late disclosed evidence. Now, we know that there was DNA evidence that was produced late, but it's interesting that there are some other things that were produced late as well. The judge was very clear that he believed that the prosecution was late in providing this information, that the scheduling order required them to provide this information prior to February 27th. And on February 27th, and at the end of the day, the state filed their 13th supplemental disclosure and provided that discovery to the defense. Some of the things that are still out that were just provided are really troubling. I realize that this is a large case, a case that has a lot of discovery involved, and they're a small office. But I've said all along, if they were going to go out and hire extra people to help with this case, they should have passed on Rachel Smith and they should have hired a discovery clerk. That's just my opinion. So some of the things that they decided that they had not yet discovered were 702 disclosures. I don't know what that means. 140 pages. Arizona certified documents, 25 pages. So I'm assuming that those Arizona certified documents would be things like death certificates, marriage certificates, official government documents. Also probably certified copies of the indictments and any of the other court documents in the Arizona cases. Then something that says Astrea, A-S-T-R-E-A. I'm assuming that is the DNA lab that did the DNA report. It says Dr. Green report, 38 pages. Dr. Wellner, 36 pages. FBI, 9 audio files and 3,460 pages. FBI sub-files, 3 audio files and 109 pages. Fremont County, 33 audio files and 441 pages. Now, Fremont County, it's very possible those are jail calls. Not sure. PAC Tech report, 8 pages. No idea what that is. Psychic essay, 76 pages. Now, we know that there have been a couple of psychics that have been very active on this case and have commented at length on the case. So, I realize that some people feel that that is important information. Other people are like, yeah. So I don't know what that entails, but certainly the defense is at least necessary for the defense to read that, even if it's just a cursory read of it. RPD, 3 audio files, 348 pages. That is Rexburg Police Department. And Social Security, 252 pages. The discovery provided is 4,933 pages and 43 audio files containing over 30 hours of interviews. That's just, it's absolutely outrageous. The very idea that this close to trial, they're turning over that much discovery, it just should not happen. And I realize that what they are doing at this point is making their argument for appeal. Defense counsel and defendant will not and cannot review all of this material prior to the jury selection starting in Boise on March 27th. So that's the first we've heard that March 27th they're going to start jury selection. The only remedy available to the court at this time, since the defendant has maintained her right to a speedy trial, is to prevent the admission of this evidence at trial. So let's just see here. The witnesses identified in FBI reports. These FBI reports begin with interviews in 2020, 3 years ago. For example, Audrey Baratario was a friend of the defendant. She pleaded the Fifth Amendment when summoned for the grand jury. The government still listed her as a witness, and so the defense reached out to her to see what she was planning to say. She refused to provide any information to the defense. Then, less than 30 days before the trial and after the court's discovery cutoff deadline, the defense received the FBI report containing the details of the interviews with the said witness. Her statements about the defendant are false. If the defense would have received this information in a timely fashion, we could have investigated the matter further. Instead, the defendant is hampered and doesn't have the requisite time to provide an effective defense. Most of the interviews from the FBI were over 3 years ago. Really? Really? That is just absolutely inexcusable. Among the 4,933 pages of late disclosed evidence is an opinion from the state's expert, Michael Wellner. Now, Dr. Wellner is a very well-known psychiatrist. He's an MD, who is the expert who determined that Brian David Mitchell, who was the kidnapper, was Elizabeth Smart's kidnapper, was malingering, which I'm sure is why the prosecution wanted Dr. Wellner to come in and evaluate Lori. We know that evaluation, at least from everything is sealed, but from some of the outward indications, it appears that he evaluated Lori at least late last year when the defense was once again concerned about her competency. So it says, Michael Wellner calls it an affidavit, although it's not dated and does not meet the definition of an affidavit under Idaho code. The defendant is not presenting a mental health defense at the guilt phase of the trial. This has been the subject of multiple hearings, and the court has ruled upon the matter. Defense experts will not present a mental health defense under Idaho Code 18207 during the guilt phase of the trial. Since the defense will not make defendant's mental health an issue during the guilt phase of the trial, likewise, the government can't make it an issue during the guilt phase. However, the government is now trying to say its mental health expert is not really a mental health expert, but actually a religious expert and an expert on evildoers. I don't know what that means. The government's current position regarding defendants' mental health is not well received. The government knows of and conceded with her commitment to a mental health facility in the state of Idaho. The government has received and read all of the reports from the treating mental health experts, both in and out of the mental hospital. The government has received and read the mental health reports from the court's independent mental health expert. All experts who have met with the defendant agree that she suffers from a mental illness in varying degrees. Instead of accepting the mental health evidence for what it is, the government wishes to change the title of their expert from mental health expert to religious expert and expert on evildoers. The court should review the CV of the government's expert and find that he has no such expertise in religious studies or in the concept of evil. He isn't published in those areas and has not been reviewed by peers in those areas. His testimony would violate the ABA criminal justice standards on mental health because he's opined a canned mental health diagnosis of her without even meeting her, and because she's not presenting a mental health defense during the guilt and innocence phase. In fact, the concept of evil doesn't even exist in the psychological setting, as the DSM doesn't recognize it. He's not an expert in evil, as there is no such thing. Dr. Wellner has not evaluated the defendant and has not requested to evaluate the defendant. So that's interesting. The government's expert cannot render an opinion one way or another that she does or does not suffer from a mental illness in the guilt and innocent phase. So they are asking the court to keep Dr. Wellner's reports out. I think that's an entirely reasonable request. If you remember, the state wanted a motion in limine, asked for a motion in limine saying that the defense could not bring in the mental health issues because they had already filed a notice that they didn't intend to bring in, they didn't intend to use mental health as a defense. And so then they said, the state said, well, if you don't intend to use mental health as a defense, then we don't want you to yell that we opened the door if we talk about her religious delusions. So those issues are yet to be ruled upon by the court, but there is a hearing set for the 15th, I believe. Have to double check that, but the court has recently set a hearing for next week. So the other motion they filed, this was filed by Lori's lawyers, is a motion to dismiss the death penalty. So what they're saying is that that dismissing the death penalty is the only sort of proper remedy for some of the things that have gone on. So first of all, they say, as the court determines its decision on the submitted constitutional motions, the court should also dismiss the death penalty for the following reasons. Media saturation of this case is still persistent. Well, in this day and age of technology, there is absolutely no way that media saturation isn't going to happen. However, as was recently shown in the Murdaugh case, it is possible for a jury to be seated and a trial to take place in a small jurisdiction and still be able to seat a competent jury who will weigh the evidence and decide the case based on the evidence that's presented to them. So I don't think that one flies. There have been multiple discovery violations by the government in this case, no question. But getting rid of the death penalty is not the appropriate remedy for that. The appropriate remedy for that is to exclude the evidence. It's not to take the maximum penalty off the table. The government wanting to kill a mentally ill person is a troubling thought. Well, it's more than a troubling thought. There is a fair amount of case law that at the U.S. Supreme Court level, that where the U.S. Supreme Court has found that indeed it is cruel and unusual punishment to impose the death penalty on a mentally ill person or a person who is developmentally delayed and perhaps unable to fully understand the penalty. So this argument is probably a little bit more compelling, but I think it's interesting. They also make the point that it is extremely difficult to for the state to carry out this kind of a penalty, that to carry out the death penalty in this day and age. I've talked a bit about Gerald Pizzuto, Pizzuto. He has been on Idaho death row for 35 years. He has exhausted all of his appeals finally, and was scheduled to be executed. The death warrant was signed and his execution was scheduled. And then a few days before, the court vacated the execution order because the state of Idaho could not obtain the appropriate chemicals that are used in lethal injection. It is becoming more and more difficult for states everywhere to find those chemicals to use in lethal injections. That's because the companies who make those drugs have unilaterally decided that they will not sell their chemicals or drugs, whatever you call them, to governments for the purpose of lethal injection. It is a political statement. It is a statement on the behalf of companies, private companies that are well within their constitutional rights not to sell to causes that that they find morally objectionable. So it is interesting that additionally, the state of Idaho, because of this difficulty in being able to find the chemicals that are used for lethal injection, there is a bill in front of the Idaho legislature to bring back the firing squad. So they make the point, moral decency certainly can't accept the thought of marching a blindfolded, mentally ill woman in front of a firing squad. not that that would be possible, because because the firing squad, she would be subject to the law. She would be subject to the law as it was before that. They won't make it retroactive. They can't constitutionally make imposing the death penalty by firing squad apply to people who, when it wasn't the law at the time. I thought there were some other sort of interesting sort of asides. They talked in their discovery motion about the fact that how did they put it? Let me see here. They talked about the fact that we don't burn witches anymore, which I thought was sort of an interesting flip comment. Of course, while I'm looking for it now, I didn't highlight it and I can't find it, but it was a little bit of a flip comment on the part of Archibald and Thomas. It sort of expressed their frustration, and I can't blame them. I cannot blame them for being incredibly frustrated with the fact that they are 3 years into this case and just now getting critical discovery. So I cannot fault them for being very, very frustrated. Now, the other thing that came out was the fact that Judge Boyce has issued his process and procedures for the upcoming trial, and how that will be managed, I guess would be the best way to say that. What we know so far is that there will be absolutely no provision for the media. The media will be treated just like everybody else who wants to get into the trial. The judge has ordered that there will be a closed circuit video feed that will go to Madison County, so that the folks in Madison County will be able, and the folks in Fremont County will be able to go to Madison County and be able to watch the live feed. There will also be a live feed into an overflow room for overflow spectators. There will not be a media room. There will not be any special provisions for the media, and the media will have to queue up just like everybody else. And they will have to, the way it will work is that there is a clickable link on their site that will pull up, and you can make a reservation for the next day, which means logically that people like me who have an interest in being in the courtroom are going to have to go online at 12:01 every day and stay on and refresh until you get your place in line. That's just the way it's going to have to work. The judge is saying that you will have to go through security and screening, and no cell phones can ring in the courtroom. And people will be subject to going through metal detectors and having their belongings searched. That's pretty typical. You cannot use any devices to take photographs or record anything going on in the courtroom. You can't talk on a cell phone in the courtroom. And laptops can be used in the courtroom if cameras and microphones are disabled. There can be no photography. Any spectator who creates a visual or auditory disturbance may be removed from the overflow viewing location or the building at any time. No one will be permitted to wear buttons or have any item on display that displays any message or any kind or engage in any disturbances or disruption. So I guess that means that your Justice for Tylee and JJ bracelets better not be on display. That said, I hope that you will all be flooding social media with photographs of you wearing them. So there will be essentially what's going to happen is you're going to have to get on at midnight every night or 12:01 every night and reserve your spot in the courtroom. And then you're going to have to queue up and have your ticket to get into the courtroom and be allowed into the courtroom every day. I am assuming that even if you have a ticket, your placement in the courtroom is going to be first come, first serve. So the sooner you're in line, the better seat you'll get. The more likely you'll be in the courtroom and not in the overflow section. So it's going to be complicated. The judge also has ordered that there will be no video feed, no audio feed other than this closed circuit live feed that will feed into the courtroom. They've also said that they've made it extremely expensive to get the daily recordings from the court. Let me look them up. It almost seems excessive. The law says that the court can recover their costs, but I don't know how this amount is. It's pretty excessive. I think it's $125 a day plus so much a minute to get the recordings. So pretty excessive. And what does that all mean? I think it all means that the judge it's one thing to restrict access pre-trial when you are sure, there you go. It's one thing to try and get, to restrict access pre-trial when you're concerned about polluting a jury pool. It's another to restrict access during a trial. As we saw in the Murdaugh case. The Murdaugh case is a great example. It was live streamed every day. There was no restrictions. And that trial went ahead. Yes, it took longer than they had anticipated, but that didn't have anything to do with the broadcasting of the trial. And ultimately, I think it was a blow for open courtroom and open trials. It was quite a triumph. I mean, they had live cameras there the whole time, and it was quite successful. And I think that it met the requirement of allowing the public to assure that their government is functioning as it's required. I think it's an outrage that the judge is treating this case this way. But in Idaho law, Judge Boyce has the final say. And beyond that, there is very little recourse. It is interesting that in the Koberger case, the media has gotten involved, and I'll try and bring you up to date on that next week. There's nothing particularly immediate going on in that companion case, but I'll bring you up to date on that next time. We're kind of getting to the point where it's time to take some questions. So We've talked about Koberger. We've talked about Vallow. We've talked about Rounds. We've talked about Murdaugh. So I guess it's open season. Hi, Don Shackelford. Can they still win this case if all this evidence is not allowed in? I suspect so. I suspect that that none of this evidence is critical to proving the prosecution's case. So I suspect that even without it, that the case probably can be proven beyond a reasonable doubt. So it's just that it's not perfect. It leaves a lot of holes that can be poked in things, and it's not okay. So the judge can keep it out, and the prosecution is going to have to live with it because it was their choice and it was their fault. So, good question, though. While we're pulling up questions, I want to thank the folks who I've seen some super chats go by, and I just want to thank you so much for those. I appreciate it no end. And I want to tell you that all of those super chat donations go directly to our moderators. Once a month, they get paid to me, and I pay them directly to the moderators. And I can tell you that your generosity is really appreciated by them. It makes a big difference for them. So thank you. And also, somebody asked me why I didn't have an account where you could buy me a coffee. So I did that this week. So hopefully Michelle will find that in the crawler and can put that up as well. Because we know I do like my coffee. But I want to say thanks to all of the donors for that. Hi, Janet. Question: discovery violations, possible evidence exclusion, lack of transparency, sealed motions, no cameras in the courtroom. Is it due to incompetence or perhaps church influence? Good questions. I think there is no question that Judge Boyce does not want the world watching him conduct this case. I think he's nervous about that. And I think that he's taken enough criticism already that I think he is very concerned about drawing criticism or documenting making mistakes. Now, anybody who watched Murdaugh, Judge Clifton Newman is a consummate, experienced judge. What a fine human being he is. And that's sort of the measure we get to hold judges up to. And so I think, I'm not sure it's due to incompetence, but I think it's due to his concern that he does not want the world scrutinizing everything he does. I don't know about church influence. I honestly don't. I have to say, I am not a member of the LDS Church. I realize that the church is a powerful political being. My opinion has always been that the influence, church-related influence, comes from the Rexburg culture, the fact that 96% of the population in Rexburg are members of the LDS Church. It comes from that cultural environment, not necessarily from the political body of the church writ large, the organization, the business organization in Salt Lake City. I still am not convinced that that church, the church, is interested enough in this case to get that far involved. I think, if anything, the church has gone out of their way to distance themselves from anything having to do with Chad and Lori. They have said from the beginning that what they were teaching was not mainstream LDS doctrine. They had strayed from the church, at least Chad, we don't know about Lori, but Chad has been excommunicated. And so my opinion is that they're doing everything they can to distance themselves from that and are not really interested in even appearing in any regard to be linked up to them. So I would be very surprised if it was church influence. I really do think that it is, according to the Idaho statute, the decision is solely with Judge Boyce. And I think that he has decided that he does not want the world watching him conduct this case. It's unfortunate because he does have a constitutional obligation to conduct a public trial. Now, I think he'd argue it is public. You can come and get up at midnight and get your ticket and come and watch, which I will be doing. But I think that he's missed the point that this is a high visibility case and that the citizens of Idaho have a right to be assured that their government employees, the people who they serve, are conducting this trial in an appropriate and proper way. So that's a good question. I guess my full answer would be not sure on the church influence, but certainly on Judge Boyce. Hi, Bo Peep. Have they decided to separate the murder charges from the financial fraud charges so as not to confuse the jury? I'm assuming you're talking about in the Daybell case. No, because from the very beginning, the prosecution has said that was part of the conspiracy. So the conspiracy was to commit the financial fraud and to murder. I think that it could have been, I still think that those indictments were sort of inartfully written, and I think it's going to give the jury a little bit of trouble. But there's so many other charges that I think I don't want to get wrapped up in that. But I don't believe that the court has not separated the murder and the financial fraud charges. Because the state argued that the conspiracy was both to defraud, to steal money, and to murder. So, good question. I'd almost forgotten about that. Hi, Trisha the trucker in Nashville tonight. Howdy from Nashville. How did Dylan's phone record his killer cleaning up after his murder? By the way, Judge Boyce is no Judge Newman. So I'll take those in turns. We don't really know. We don't really know if Dylan's killer accidentally turned on and recorded himself on Dylan's phone. We don't really know. But we do know that there was a video found on his phone of his alleged murderer, cleaning his gun covered in blood. We don't know what that means, and we know that's a circumstantial case once again, just like Murdaugh. And we know that when they found that shirt that he had been wearing in the video, it contained blood both from him and from Dylan. So I don't think we know enough. Remember, this is just the probable cause affidavit. So all they really have to do is prove that there is enough evidence to hold the defendant over for trial, to bind him over for trial. So I don't think we know enough yet about the sequence of events. They may not know. But it is interesting to me that a phone that was submerged in a pond later was able to have data extracted. And as we saw in the Murdaugh case, it may very well be that data that was extracted that turns out to be the sort of the pivotal piece of evidence. I will agree that Judge Boyce is no Judge Newman. Judge Newman has been on the bench for many years. He has a wonderful judicial temperament. I can tell you that I admire tremendously judges who have that, people who have that judicial temperament. I don't have it. And in the during the times that someone said to me, "Hey, do you have any interest in being a judge?" I said, "Oh, hell no. I don't have the temperament for it, and it would be very unpleasant for me and for everybody who appeared in front of me." And I have met some unhappy judges who realized that the job wasn't all that they thought it was going to be, or were unhappy in their job, and it makes for unhappy justice for everyone. So I admire Judge Newman immensely. I think that he is probably the gold standard for a criminal judge. Very educated, very wise, very well spoken, very well versed in the law. So I think anybody who appears in front of him, probably he's a joy to appear in front of. And Judge Boyce just doesn't have that kind of experience. He just is not. He's young. He's inexperienced. And I will say that I think that in these past few hearings, I see him finding his feet somewhat in this case. I think that it took some courage on his part to change his mind about severing the cases. And I think that that was a sign that is willing to consider when things change. So, by the way, I wanted to mention that we are within like 10 subscribers to hitting 5,000 subscribers. So if you have not subscribed, please consider doing so. It helps us. It helps the algorithm. Please hit the thumbs up button. But I also want to remind you that once the Daybell case starts, our schedule is going to change. We're not going to be doing these lives quite as often, but we are going to be doing shorts from the courthouse as often as I possibly can. So if you are subscribed and you hit that notification button, then you'll get notified whenever we go live. And those are going to be important because, as we know now, no cameras in the courtroom. So I get to be your ears and eyes in the courtroom. Please consider subscribing so I can keep you up to date on what's going on. And we can hit that 5,000 mark. Thanks. Meadow Crone, question: if they exclude it all for Lori, can it be included for Chad? Yes, it can. Because the reason it's being excluded is because of the late production. And the reason it's being excluded and the cases were severed is because Chad needed more time to process and understand all that information. So it won't be excluded at Chad's trial. Good question. So that will be very interesting to see how that late discovered evidence may impact Chad's trial where it hasn't for Lori. Guys, it made me talk a lot tonight. T Diva, in my opinion, whose trial will be longer, Chad or Lori? Well, that's a good question. I think there's some factors that could go into that. As the last questioner just asked, whether or not that additional discovery that could be excluded out of Lori's case could be introduced at Chad's. So that's one factor. There could just be more evidence coming in. The other factor is the defense and the prosecution are both going to have, Chad's trial is going to be kind of like the second bite at the apple. because both will have had the opportunity to see what happened at Lori's trial. The defense is going to be able to look at Lori's trial and say, now we know what their theory of the case is, and we can prepare for that. The prosecution, on the other hand, is going to be able to fine-tune and hone their presentation. So that could result in a shorter trial for Chad, because the prosecution will have a better, will just have had some practice. And so we all know that the more often you do something, the better you're going to get at it. So it's possible that they can kind of refine their case, and that could make it shorter. So I don't know. I mean, on balance, I would be very surprised if Lori's trial takes more than 6 weeks because of the severance. I think initially when the prosecution predicted 10 weeks, they were talking about the fact that they felt that it was going to be that long because it was going to be both defendants. So now that the case has been severed, I would be surprised if it goes beyond 6 weeks. But we also have to factor in that if there is a guilty plea, there will be a penalty phase. So it could be 6 weeks of trial and another 2 weeks of penalty phase. We don't know. But at least to start out, I think it will be shorter than their original prediction. Good questions tonight. Deborah Dapo? Question: once the cases are over, would we get to see the videos? I'm assuming you mean the recordings of the court proceedings. I think it is possible, but I think at this point, somebody's going to have to pay for them. Because as it stands right now, the only way that we're going to get them would be somebody's going to have to pay for them. Just the same way as somebody has to pay for the audio recordings. So, yeah, unfortunately, they're going to make it expensive to actually be able to see this trial. Hi, Ladybug Lady. What does it take to get a judge removed from the bench? I'm starting to feel like constitutional rights of people are being violated, in my opinion. Yeah. So in general, here's the sticky part of judicial appointments. Usually what happens is judges are appointed if there is a vacancy, a midterm vacancy for a judge. The governor appoints that judge's replacement, and then that person runs at the election as an incumbent, and that's sort of typically what happens. In my time, I saw a couple of judges who retired by not running for another term, and what that meant was that there had to be a contested election. But that's not a common occurrence. In general, what happens is people let the governor's office know that they're interested. The governor's office puts together a slate of potential candidates. They select someone, and then that person fills the vacancy and then runs as the incumbent in the next election. So it's difficult to remove a judge unless that judge has committed some sort of misconduct. There is not a competence test for judges. There is not an ethical obligation the way there is. Well, I don't mean to say that. In our professional rules of professional responsibility, it is a violation to take on a case that you are not adequately prepared for or educated for. Now, it also says that you can become educated. I mean, if you've never done a personal injury case before and you take one, you are expected to obtain the expertise necessary to professionally pursue that case and represent that client. But, and I think there is an ethical obligation on the part of judges. But it is very difficult to remove a judge from the bench on competency. It is much more likely that a judge gets removed from the bench for misconduct or for if the judge has alcohol or drug problems, mental health problems, those sorts of things that make them unsuitable for the bench. That's something different. But to remove a judge just because you think they're not the best guy at their job, they're just sort of average. Yeah, that's pretty hard. And I mean, to be honest, I think Judge Boyce is right now, I think he's fine. He's just inexperienced. And I think the inexperience has led him to make some mistakes. So we'll see. Because the remedy for a judge that makes mistakes is an appeal. Michelle question, which is more important, proving the conspiracy or DNA evidence? Well, it kind of depends on whose DNA it is. If the DNA turns out to be somebody and it's inculpatory, then the DNA evidence is important. But I think proving the conspiracy is way more important because it doesn't require that the prosecution prove that Lori Vallow put her hands on her children and ended their lives. It only requires that she conspired with other people and took a substantial step toward doing that. So it's a very different, I won't say it's a lower level of proof because it's not. Everything has to be proved beyond a reasonable doubt, but it's a very different thing to prove that than it is to prove that she hands-on murdered her children. So I would say the conspiracy is probably the most important thing that the state needs to prove. Mary Torbert. Hi, Mary. Any plea deals for either Lori or Chad? Not that we know of. Now, we have heard rumors. I have been hearing rumors for a couple of months now that there have been plea negotiations going on. I've heard a lot of rumors about that, but I have heard nothing that I could substantiate or repeat at this point. Now, understand that plea negotiations can go until the verdict comes in. I mean, I've seen cases where juries have been seated and evidence has begun to be presented, and the defendant has said, wait a minute, I want to enter a plea. I want to take advantage of the plea. If the plea is still on the table, I want to take it. And so they could enter a plea. Either one of them could take a plea right up until the jury says guilty or not guilty. I think that typically what happens, though, is once trial starts, the prosecution says, we're not going to honor that deal anymore. That deal's off the table. And the prosecution usually puts a deadline on when the defendant has to decide and say yay or nay. So, but I have heard rumors and rumblings that there are continued plea negotiations going on. Chachi's mom. Isn't it BS that you got to pay to see when the citizens are already paying for their defense, public defenders, etc.? The citizens of the state deserve to watch it free. I could not agree with you more. I think it's BS that the citizens of this state and of Ada County and of Madison and Fremont County are already paying for the courtroom, for the courthouse, for the public defenders, for the all of that, for the judge's salary, everything. And I think that it is wrong that they should have to pay to be able to see their government in action. The reason why we want fair and open trials and we want fair and open court is because it is our responsibility as citizens to assure that the people who work for us, our public servants, are appropriately carrying out their duties in an ethical, honest way. And the quickest way for that to erode is to remove access. So I agree completely. It is outrageous that that somebody is going to have to pay for those recorded court streams in order to make them public. Dinah Lynn. Question: what is Lori's strategy for not waiving her right to speedy trial? I think her lawyer would prefer that she had. I guarantee you that her lawyer would prefer that she had. I guarantee you that he would like way more time to prepare for this trial. I'm not entirely sure what Lori's strategy is, other than the fact that I think that she had some influence, potentially from her father, Barry, who always thought he was a lawyer, or from her previous lawyer, Mark Means, in saying, never, never, never waive your speedy trial. Always hold the prosecution's feet to the fire and make them go forward. I think that that is a strategy. The other thing I think is that she honestly believes that she will be exonerated. I don't think that that is I don't think that's hyperbole on the part of her lawyers. When they say in their court document, she believes she will be exonerated. She believes that for whatever reason, that she believes God's going to deliver her from this and she will be vindicated. And I think she feels like the sooner that happens, the better. And she is not prepared to spend another day in jail without getting her day in court. So I think those are the two factors, because I certainly agree that her lawyers would like more time. So we're getting toward the end of the hour. It went by like zoomed by with so much to talk about. I hope, let's see, I see in the comments, Nate Eaton says East Idaho News will pay for them. I don't know whether they'll release them without a paywall. That's interesting. I'm sure that there are other media outlets and folks who are interested in maybe going together and being able to get those videos. It's going to be expensive. No matter who does it, it's going to be expensive. And so the more likely it is that people can kind of spread that expense around, the more likely it is that we can get it out there and where y'all can see it. So I have talked to a couple of people who are potentially interested in either doing a GoFundMe program or trying to get together and pool resources to try and see if we can purchase those to make them publicly available. So stay tuned, because I think there's going to be much more to talk about in that in that going forward. I mean, in my opinion, they need to be out there and they need to be public. If I'm involved with a group that raises the money, it would be for them to be public. I would never put them behind a paywall. That's just doesn't make any sense. But stay tuned and I'll let you know, because it may be a joint effort among a lot of people to get together and try and chip in to make sure that those those are available. So I'm going to wrap up. Thank you so much for joining us tonight. Thank you so much for supporting our moderators. Thank you, Brown Eyed Girl, that's Brenda, and to Michelle for their always being here and being faithful. Thanks to all of you who dropped them a few bucks for in super chats. We appreciate it immensely, and it all goes to them. Thank you for being here tonight. I know that there's a lot of Teresa. It could very well be my cat meowing. He was just sort of wandering up and down the hall, and he's Siamese, and so he's got a big mouth. Thanks once again. Please hit the likes. Please subscribe if you hadn't. Please edge us up over that 5,000 number. We'd appreciate it. And be with us on Friday when we're going to talk lots more about Vallow Day Bell. And we'll also talk a little bit about any developments that come up between now and Friday in the other cases we're following. But we always take that deep dive into Vallow Day Bell on Fridays. So I'm your girl when it comes to being in court, and I'm going to do everything I can to make sure that you all have as much access as possible to the trial once it gets started. And I'll let you know as we go forward what else to expect. So thanks for joining us. And I'm going to say